You know how sometimes a small disagreement with a neighbor can just explode? Well, we've got a story for you today that takes that to a whole other level. We're talking about a full-on battle between a couple of homeowners and their HOA. And this whole thing revolves around a security camera and some meeting minutes that seem to have vanished into thin air. Let's get right into it.
Okay, so here's how we're going to unpack this whole thing. First, we'll set the stage, get the background on this dispute. Then we're going to tackle the two big fights, the mystery of the missing minutes and this standoff over the security camera. After that, we'll look at how both sides are interpreting the rules to fit their argument, and of course, we'll wrap up with what the judge decided.
All right, so let's meet the players in this neighborhood drama. First up, we've got the homeowners, Kevin Schafer and Patricia Lawton. And going up against them is the Sycamore Springs Homeowners Association. Now, this isn't playing out in some big formal courtroom. It's happening in an administrative hearing in Arizona, which is pretty much a special venue set up for exactly these kinds of disputes.
And get this whole thing has been dragging on for a while. The hearing itself got pushed back not once, not twice, but 3 times over the span of 5 months before they even got started. I mean, that alone tells you just how long this conflict has been simmering.
Okay, let's get into the meat of it. We're not talking about a simple misunderstanding here. According to the homeowner's lawyer, what we're seeing is just the latest battle in a much longer and pretty bitter war.
And yeah, their lawyer did not pull any punches. Right out of the gate, in his opening statement, he said these folks have been in some form of litigation for about 5 years. And then he drops this word, targeted. That really frames their entire argument, right? The idea that this isn't about rules, it's about the HOA being out to get them.
So where does this whole thing start? Well, the first major point of contention is about something that sounds kind of boring, honestly. Access to HOA records. Seems straightforward, right? Heh. Well, as you're about to find out, it's not.
Look, all Patricia and Kevin wanted was to see some documents, specifically 5 sets of board meeting minutes and a couple years of financial records. You'd think, as members of the association, that'd be no big deal. But the HOA wasn't exactly forthcoming.
And this is where it gets kind of wild. This whole part of the argument boils down to the meaning of a single 4-letter word in the state law, keep. I mean, what does it really mean for an HOA to keep records? Does it mean they actually have to create them in the first place? Or just, not throw them away if they happen to exist?
It's pretty amazing, right? You've got 2 completely opposite interpretations of the same word. The homeowner's argument is simple. Keep implies you have to create and maintain them. It's common sense. But the HOA's view? Totally different. They're saying keep just means to retain. So, if we never create the minutes in the first place, there's nothing for us to keep.
And the HOA's lawyer really doubled down on this. He flat out said, they've conflated the word keep to mean take. His point was, look, the words are different for a reason. If the law meant for HOAs to take minutes, it would have used that word. But it doesn't. It says keep. But then, you get this huge reveal during the testimony. The HOA president herself gets up there and admits, yeah, the board stopped taking minutes specifically because Patricia was asking for them. Whoa. So this whole debate about legal definitions, it suddenly looks less like a simple interpretation and a lot more like a deliberate move to block them.
Okay, so that's the paper trail problem. Now let's switch gears to the other major conflict, the security camera. And this is where things get personal, with arguments about privacy, property rights, and who really has the power.
So the backstory is pretty simple. The homeowners put up a new security camera. A neighbor was not happy about it, filed a formal complaint, and that triggered the HOA to send a violation notice. The core of it was, you can't just install that without getting it approved first.
So naturally, everyone goes to the rule book, the CC&Rs, and there's this one sentence that's causing all the problems. It's a bit dense, but it basically lists a bunch of things you can't install, like speakers and bells, but then it has this little clause, except security devices used exclusively for security purposes.
And just like with the word keep, both sides read this completely differently. The homeowners see that phrase, except security devices, and say, that's a carve-out. My camera is a security device, so I'm exempt from needing approval. But the HOA, they argued that exemption is only for sound-based devices, like a driveway alarm that beeps. They say a video camera is a whole different ballgame.
And let's be clear about the neighbor's complaint here, because it wasn't trivial. They had real privacy concerns, especially for their kids. They said the camera overlooked their property, and they were worried about being recorded when they were just trying to relax in their own hot tub. You can see why the HOA felt they had to step in.
So we've got these two major fights, and in both cases, it all comes down to how you interpret the governing documents. Let's just quickly recap the arguments on each side.
It really breaks down like this. On the missing minutes issue, the homeowners say keeping implies creating the records. The HOA says, no, it only means not destroying them if they exist. Then on the security camera, the homeowners point to that specific carve-out for security devices. The HOA counters by saying, yeah, but cameras are considered an attachment to the house, and all attachments need architectural approval. It's a classic battle of specific rule versus general rule.
And that brings us back to the homeowner's main theme, that this is a targeted attack. Their lawyer made a big point of this, saying that for 22 years, the HOA basically ignored other cameras. So why all of a sudden are they coming down so hard on his clients? It feels like a witch hunt to them. The HOA, on the other hand, frames it as a matter of duty. They argue, look, we received a formal, serious complaint about privacy from another resident. We have an obligation to enforce the rules for all residents. If they just let it go, what kind of precedent does that set?
So, after all the back and forth, all the arguments, the hearing finally wraps up. But that's not the end of the story, not by a long shot. So what's next?
Well, the process is pretty straightforward from here. The hearing is over, which means the official record is now closed. No more arguments, no more evidence can be submitted. The ball is entirely in the judge's court, and she has 20 days to issue a formal decision.
So think about that. After a 5-year dispute, all this tension and litigation, it all boils down to how one administrative law judge is going to interpret a handful of words like keep, attachment, and security device. The entire outcome of this long-running fight rests on the definition of those terms.
And really, this case just highlights a much bigger question, doesn't it? When you live in a planned community, where do you draw that line? The line between an individual resident's rights to their property and the board's authority, their duty even, to enforce the rules for the good of the entire community. It's a fundamental tension, and it's something people are grappling with in neighborhoods just like this one all over the country.